Hey everyone, Harry here to talk about Donald Trump's effort to delay, but not in Manhattan, in Fulton County, and not him alone, but with all his defendants. Okay, so Trump and company, the many defendants in Fulton County, have filed in front of Judge McAfee a motion to ask McAfee to permit or authorize, sort of green light, a appeal, an immediate appeal to the Georgia Court of Appeal of McAfee's denial of Trump and company's First Amendment motion, which argues that the indictment has to be dismissed because it seeks to criminalize core political speech. It's a really lousy argument that has been routinely rejected. They recall what's left in Fulton County is a RICO count is the main the core of the accusation that says there was a basic scheme, and the scheme was to steal the election from Biden and deliver it to Trump, and it had many different aspects. But the notion that it's core political speech, there's this sort of sophistry of saying, well, we're talking about the election, and indeed, when, let's take the famous January 2nd phone call to Raffensperger, where Trump says, I just need 11,708 votes. Speech about an election, core political speech, not so much, because speech integral to the commission of a crime, as all this speech is neither protected nor considered core, even remotely. So likewise, pick your overt act. Giuliani goes down to Georgia to try to badger them into breaking the law and finding there's a problem. Speech, yeah, about the election, yeah. Core political speech, not so much. In fact, not at all. Trump tells Pence that he has to, depart from his constitutional role under the 12th Amendment and punt this to the states. Speech, yeah, about an election, yeah. Core political speech, not so much. Rather, speech connected and integral to a crime. So the underlying claim is lousy, which is why McAfee readily denied it. What about the claim now to get an immediate appeal? Because as most people know by now, you don't get appeals. Usually you have to wait till you're convicted at trial and then bring them all together. You don't bounce up and down, up and down, up and down before getting to trial, which would be inefficient and would take away from the import of the trial itself and the like. There's an important exception to that, and Trump has mined that exception for all it's worth, and that is when you claim or make an argument based on immunity, as he's done most noticeably in the Chutkan January 6th trial, and the argument that the Supreme Court is now going to hear before trial. And the reason there's an exception there is because the right in question is not to be tried in the first place. So if you couldn't appeal it immediately, then you really could lose the right would not amount to much. Because you could be forced into trial and then bring your appeal after and say, I had a right not to be tried. Oops, sorry, that happened. So that is a rare exception to the general principle that you bring claims after trial, and this First Amendment motion is not one. In fact, there's a kind of screaming silence of absence of law in the Trump motion. Here's what they try to say, that the core political speech, they can't even say, they want to say, but there's a few counts that make it impossible, that nearly all the counts in the indictment, starting with the RICO count, are concern or seek to criminalize core political speech. So nearly all, but of course not all. And imagine a case of a single count that is, you don't get to try to appeal the First Amendment claim later. But in any event here, for all the reasons I said and McAfee said, it isn't about core political speech. But even if it were, their argument is, so it's most of are about core political speech. And if we were to win on appeal, that means nearly the whole case would go away. And here's the big legal principle, get ready. It would make sense to do that. That's the legal argument, as it were. Wouldn't it make sense, Judge McAfee, to have the First Amendment claims be heard by the appellate court before we go to court, before we go to trial, and then the whole thing might go away? And wouldn't that make sense? You wouldn't have to do the trial at all. But the wouldn't that make sense principle is not a legal theory for getting an interlocutory or before trial appeal. And so it's really a lousy and flailing kind of motion. They hope I think they can't expect that they would even win it. So the hope has to be that somehow, for no good reason, McAfee, who's no fool, would greenlight the appeal. Then it would go up. Everything would be on ice, and for sure would push things over the November election day. Recall that seems unclear or unlikely it could happen, but at least the refrain that Fani Willis is now repeating is, let's have trial right away. Let's have it in July or August. So this would punt it to the other side. So two problems with the motion. The basic argument that they have a good First Amendment claim is really weak, and the basic argument that they, if they had such a claim, could bring it right away before trial is, I guess, even weaker, because there's no law at all, but just a made-up principle that it would make sense to do it for that reason. So I don't see this going anywhere, and it's really a long shot Hail Mary to try to get a delay. So that shows something about the mindset and strategy of Trump and the several all his co-defendants in Fulton County, but don't expect, in fact, expect this to be denied. And if they have a First Amendment appeal, an appeal that is from McAfee's denial of their First Amendment claim, it will have to be brought after conviction and many moons from now. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.